This is the Professional Edge, and thank you for listening. My name's C. Todd, tax attorney, CPA, and certified financial planner, and we are talking about Beyond the Will, comprehensive estate planning. We touched on some testamentary trusts for your children. In the prior session, we talked about how we could leave some assets to our surviving spouse and assign an advisor in the previous session. And this one, we're going to talk about a little bit more on that surviving spouse, because one of the individuals may not understand investing and what we need to do with the portfolio to keep this growing, and they're not too in tune with things, which is fine. That's perfectly okay. So why wouldn't you assign them, basically leaving them your assets, and let's go ahead and leave those assets to the surviving spouse in trust. Now, we can have the surviving spouse be the sole trustee, sole beneficiary, so we're okay. Or if that surviving spouse is not too financially literate, we're going to assign, let's say, one of the children as a co-trustee on those assets for the surviving spouse. Now, we're going to go one step further and go beyond the will. We've established this testamentary trust for the surviving spouse. There's another reason why we're going to do that we'll cover coming up. And then we're going to have this comprehensive planning because A, that surviving spouse is not financially literate, which is okay. So therefore, we're going to assign them a financial advisor to those trust assets to make sure they are properly allocated, invested, tax strategy is applied, and therefore the surviving spouse is not going to get sharked, as we call it, and taken advantage of. These are there, they're prudent, they're allocated. The financial advisor is there to assist them in making the right, proper financial decisions going forward for that surviving spouse. Now, think of the peace of mind that you, as a listener here on the Professional Edge, would have. Let's say your spouse, could be husband, could be wife, it doesn't matter. Your spouse doesn't really understand the financial side of things, so part of your going beyond the will, you say, you know what, let's place these assets in trust for you. You can be the trustee, you can be the beneficiary, but let's assign a financial advisor to you to help you understand and move this thing forward when I, the decision maker regarding investments and taxes and all those good things, I pass away. I want to make sure that you are in good hands with an advisor going forward when I'm not here to make these financial decisions. Wow, what a peace of mind you would have knowing your surviving spouse is going to be in good hands going forward, and the assets that you leave them are going in trust. And it's in this irrevocable trust. Now, why is that important? Well, that's very important because that irrevocable trust statute says that these assets are protected from the potential claims of creditors. So let's say, lo and behold, the automobile insurance policy did not get paid during that first year of your passing. Well, no fault of their own. They're just in a fog because a lot of surviving spouses, it takes about a year to come out of the fog of losing their most loved one in their life. They may have been 30, 40 years with this individual and now they're gone. Well, it happens. That policy for the insurance may not get paid. Lo and behold, before you know it, they're involved in a serious automobile accident. The insurance company says, well, we never received your premium. We tried to contact you these several different ways, and unfortunately, the policy has lapsed and you have no automobile insurance coverage. And if this is a six-figure claim, a liability claim for the injuries that you caused, well, guess what? Your entire assets are exposed to the potential claim of that automobile accident on that plaintiff. You will be sued. So now you've exposed your assets to this potential claim, and wouldn't you like to know, okay, my other assets are exposed, but my deceased spouse had enough foresight to go beyond the will to do some comprehensive estate planning and left me their assets in trust, a creditor-proof trust that if I lose this lawsuit, I'm not going to lose everything. I still have these assets that my spouse left to me in trust, and those are going to be mine. They are going to be creditor-proof. That would be an incredible afternoon to know that you cannot lose these assets. Think about that for 1 second. Your surviving spouse is going to have a trust full of assets that they're not going to lose to the potential claim of creditors. That right there is enough for me to say, hey, you know what? I probably need to go beyond the will of leaving everything to my surviving spouse and equal shares to my kids, and go beyond that will and do some comprehensive estate planning. This might be the wake-up call to give our office a call at 877-654-9798. That number again, 877-654-9798. So that's going beyond the will and doing some comprehensive planning. Now, if you have that child that has special needs, we all know that what we need to do for that child is when you pass away, that their share of your estate goes into what is known as a special needs trust. So therefore, they are still qualified for receiving their government benefits and entitlements. It is not going or gaming the system. It is protecting that beneficiary from having to spend down all the assets that they inherit before they requalify for their government entitlements. It's a safety net. Now, if you don't do it right, you leave it to them outright, then they are going to actually be disqualified from their government entitlements until they spend down these assets. And then once they spend down these assets, they are now eligible to requalify for government entitlements. But think about this, there's no safety net. The family now has to take responsibility if there's any need of that special needs beneficiary. So that is another wake-up call. If you don't have your special needs trust in force in place and you pass away, then you know what? Your assets will be spent down for that special needs beneficiary, and then they're going to have to requalify to get back on the government entitlements. That would be a disaster. That is not what you want to have happen. So going beyond the will, your comprehensive estate planning on what you're trying to do and trying to accomplish. So here's another way to go beyond the will. Well, let's say that you have some real estate here in your domicile state of Georgia, and then you have some real estate in Alabama, you have some down in Florida, and lo and behold, you do not want to have ancillary probate. So here's where you got to go beyond the will and do some comprehensive estate planning. That is, you want to probably establish a revocable living trust, transfer that real property into the name of the trust, and therefore, when you pass away, your estate, those assets contained in that revocable living trust, are going to be exempt from having to go through the probate court process. We would be able to administer your estate within the confines of four walls and a closed office door. How about that? You just avoided probate with that real property in the state of Georgia, the state of Alabama, and the state of Florida. Wow. That right there, enough. Think about it, because a Georgia attorney has to be licensed in Alabama, licensed in Florida to probate those estates there. So now you got three attorneys talking to each other, and we talk real slow when we talk to each other because we bill by the hour. So think about that. Let's avoid that whole conversation between three lawyers that will talk real slow and bill your estate. So beyond the will, you got real property outside of your domicile state. Well, let's go beyond that. Let's establish a revocable living trust, place the real property in that trust, and therefore you will avoid ancillary probate, and you will avoid probate in your great state, your domicile state. So that enough. Think about it. You have real property outside of your domicile state. If you don't have things properly done and you have that will, you will have your probate estate in the state of your domicile, and you will have ancillary probate to get that property located outside of your domicile state, probated. So give our office a call at 877-654-9798. That number again, 877-654-9798. So that's doing that comprehensive estate plan. So let's think about this. Beyond the will, comprehensive estate planning. Well, you have that condo down along the Panhandle and you put it in the Airbnb or rental property. On that, you're claiming it on your taxes the way you should. That's perfect. But ask yourself, as a listener here on the Professional Edge, how do you have that condo titled? Remember, you bought it together with your spouse. You have it on deed. You probably refinanced it a couple times, maybe in, out, don't know whose name it's actually in, but let's say it's still jointly held. Well, lo and behold, if I'm a tenant and something happens to me, you have just exposed your personal assets to the claims of that tenant who got injured because you didn't repair the railing. And I fell 3 stories. I didn't kill myself, but I am now a quadriplegic. Well, lo and behold, that will be a multi-million-dollar lawsuit. And if you do not go beyond your will and do some comprehensive estate planning, which includes asset protection planning, then you've just exposed your estate to the potential claims of that creditor. So that's a bad afternoon. So why don't you take the initiative, and if you, as a listener here on the Professional Edge, you have that rental property, it doesn't have to be on the Panhandle. It could be right here in the great state of Georgia. It could be in Atlanta, it could be in Columbus, could be down at Milledgeville. Who knows where you may have this? You may have some college condos that you rent to college students. It doesn't matter. What matters is how you have title to those assets. And ask yourself, as a listener here on the Professional Edge, if you still have those assets in your individual name and you have tenants paying you rent, this is your wake-up call. Go beyond the will and do some comprehensive estate planning, which includes asset protection planning, and isolate those liabilities so therefore your tenant can't come get your personal residence, can't come get your car, and cannot get your brokerage account. Give our office a call at 877-654-9798. That number again, 877-654-9798. Go beyond the will and do some comprehensive estate planning to isolate the potential creditor exposure that you have on those rental properties. So again, my name's Sean Todd, tax attorney, CPA, and certified financial planner, host here on the Professional Edge. I appreciate you listening in. And another segment.
We've all thought about it. Everyone listening will need one. Not having one can cause untold heartache, family conflict escalating to the point of a lawsuit. One simple thing that avoids all that: an effective estate plan. As a practicing tax attorney, Sean Todd with Estate Management Counselors has completed over 1,000 estate plans during his 15 years of professional practice. He can help you implement an effective estate plan, coordinate your financial accounts, and make sure you have named the proper beneficiaries to maximize your tax savings. Call 877-654-9798 today and let tax attorney Sean Todd help you implement an effective estate plan. Call 877-654-9798 today. As a tax attorney, CPA for over 15 years, Sean Todd has implemented over 1,000 individual estate plans. He has recently authored an especially helpful guide, How to Unlock the Ultimate Estate Plan. This guide has helped many individuals to understand the benefits of an estate plan and how to avoid unintended disasters. Sean has made every attempt to write this in plain English. To receive this valuable guide, How to Unlock the Ultimate Estate Plan, call 1-877-654-9798 and request your complimentary copy today, or by emailing your request to info@emcadvisors.net.